Hi, hello, and welcome to Why a Trust is Right for You. I am Andrew Gilliland of Gilliland Law. Here's a picture of me so you can tell what I look like. I just want you to know, though, that I do love what I do. I have the opportunity to work with you to make sure that everything you have worked for or will work for during your life does not end up in the hands of others or does not destroy your family. To better advise you, a little background information on me, I do have a degree of master's in taxation from the University of Florida. Go Gators. My goal is to understand you and to make sure that your estate plan satisfies your goals. I do take the role of legal advisor and counselor seriously, and I apply my real world experience to create a solution that works for you. I do look forward to meeting and working with you to figure out what estate plan would work best for you and your family to protect them and protect you, as well as protect your legacy, which is very important. All right, so let's talk about what an ideal estate plan is, okay? The goal here is just kind of introduce some of the estate plan basics that most people would agree would be ideal to end up with after you're done with your estate plan. First goal is always going to be to avoid paying estate taxes. No one really likes to pay taxes, especially estate taxes, which can run very high. If you qualify, fortunately, the estate tax exclusion amount is over 22 million, so very few individuals actually fall into that category. So avoid estate taxes, yes, that's great. So also avoid income taxes. When you properly plan, you're able to move assets around and ownership of assets in a way that will maximize or minimize, I was going to say maximize the income tax benefit, but minimize the income taxes that would have to be paid on those assets. All right, also another ideal estate plan would avoid dissipation of assets from irresponsible spending. What this means is if you have an heir, could be your surviving spouse, could be a child, and they have spending issues, they rack up credit card debt, they may have potentially creditor issues, or maybe they just have bad marriages. And so the idea is, how do we plan around that? That's what an ideal estate plan will do, keep and protect those assets from themselves, not just spending it from third parties, but also from creditors attacking those assets. Which is the next point. Avoid from creditors, predators, and divorce. All these are aspects of an ideal estate plan. Finally, an ideal estate plan would avoid court control. We'll get into this a little bit more about probate, guardianship, or conservatorship, as much as possible. I might add here too, just a thought, an ideal estate plan, really you're planning for sort of three areas of life. You're planning for incapacity. You're planning for who's going to take control of your stuff should you not be able to. And that stuff includes your assets, could be your business, your home, paying your bills, takes care of that side of it. The other aspect of it is your medical decisions. Who's going to have access to your medical information so they can make those decisions? What direction do you want to give them through a living will? And then how do you want those to be carried out? Another aspect, so that's sort of the one, planning for incapacity. The second part of an ideal estate plan would be to plan for your untimely demise. If an accident were to happen tomorrow, next week, next year, what would happen in that situation? Do you have young children that need to be taken care of? Do you have adult children that you need to take care of in the sense that, protect them from themselves? And then finally, the third part of an ideal estate plan will look at should you pass at the end of your, down the road when you're older. So no accident, no untimeliness. It's just at the end of the day, you've reached your full potential. That's the third part of an estate plan. And there we're dealing with how our assets going to be transferred, which we are in that second time frame too, but the considerations tend to be slightly different because ideally you'll have adult children by then who can take care of themselves. You'll know a lot more about them. You'll have assets that need to be transferred. That's what an ideal estate plan will deal with. So yes, it will avoid estate taxes. Yes, it will avoid income taxes. And yes, it will avoid dissipation of assets from irresponsible spending and avoid a tax. All right, so now let's talk about how can you create an ideal estate plan. All right, so keeping in mind the goals of an ideal estate plan that we just discussed, let's consider some options everyone today here has. All right, we have what's called doing nothing. It's always an option, right? It's not a very good one, though. Doing nothing puts the government in control of your estate. People without plans often expose their heirs to unnecessary estate tax or income tax. The government's plan, which is called intestacy, you can see it up there, provides no protection against predators, creditors, divorce, wasteful spending, and as you've probably already expected, it puts the court, rather than you or someone you trust, in control. So do nothing is never the best plan. All right, use of joint tenancy, beneficiary designations, transfer on death, etc. Joint tenancy usually comes up when real property, right? You know, so and so and so and so as joint tenants. Okay, joint tenancy means the last of you to survive gets the property. Beneficiary designations are like your IRA, your retirement accounts, life insurance, right? You designate in this contract who's going to get those assets outright when you die. Okay. Transfer on death is more like a bank account or some other type of account where it's essentially like whoever's on the account with you gets it. It's a little bit like a joint tenancy, but joint tenancy tends to be far more in the real estate context. Okay, that's another option you have there. You can also do what's a will-centered estate plan. Okay, a will is a legal document, and we'll talk a little bit more and go through this a little bit better. It's better than doing nothing, maybe better than a joint tenancy. It allows you to appoint who's going to control your assets, being your executor or personal representative when you pass. Allows you to designate your beneficiaries, but again, not the most ideal. The fourth one here is the most ideal, a trust-centered estate plan, which we'll get into a little bit more. But I just want to be clear at the outset that estate planning is more than documents. You can get documents online. But the key is, do those documents know you? Do forms know you? You got to keep in mind what a form is, right? A form is nothing but a plain vanilla one-size-fits-all created by somebody, right, who doesn't know you, doesn't know your family, doesn't know your situation. So estate planning requires thoughtful consideration of your goals paired with implementation of specific strategies to achieve them. All right, so let's talk about how your estate will work with a will, or without a will, I'm sorry. All right, I've often heard it asked, well, what do you mean when you say an estate, okay? An estate is essentially all your stuff, like investments, right? It's heirlooms and personal property, it's bank accounts, it's home and real estate, and it's other property. Basically, everything you own when you pass is part of your estate. All right, without a will, as we've already kind of discussed, if you've done no planning at all, no will, no beneficiary designations, no joint tenancy, no trust, literally nothing at all, everything will end up in probate court, okay? Probate court, well, let's talk about probate is the process whereby the court will make certain determinations about your estate. They gather it all together, so your estate is all gathered together. It's public, it's reported to the court in open court. Documents are filed saying this is the estate. Okay, the probate court then will appoint somebody to handle your estate, including dealing with creditors. Okay, so a probate court will deal with gathering assets as well as appoint somebody to deal with creditors. So the downside, though, of probate is really, it's significant, that the probate fees could be thousands of dollars. You know, there's filing fees, there's attorney's fees, and yes, even the person appointed as the personal representative gets fees. There's also a probate referee, things are appraised, a lot of fees go there. There's also no protection for taxes. We can't plan for specific assets or specific heirs how to deal with the taxes. And here's the real kicker. Heirs are decided by the government through intestacy law. Okay? That essentially means the government, well, first of all, the probate court will determine who your heirs are, and then they'll look at what each one of them should get at the end of the day. Okay? So you can see that downward arrow there. Everything goes in, bam, one arrow bit goes out for taxes, bam, another for probate fees, and then finally, when the probate court determines who your heirs are, and it's going to be your children, surviving spouse, usually. They'll get what's left after all those. All right, so let's talk about how your estate works with joint tenancy. Okay, so I've moved it over slightly, you can tell there. And again, just to sort of recap, we got everything going into probate court, right? We got probate fees, heirs, beneficiaries, taxes, etc. All right, so with joint tenancy, let's look at this. So now we take this bank account. Let's say you put someone else on the account. That someone else then would get it all. So in our graph over here, let's say you have 3 heirs, okay? One of them is on the account. The other 2 get nothing from it. It all goes outright to the individual on the account. All right, say the same thing here. Let's say you have a home. It's in joint tenancy, right? It's heir number 1, the one on the far left, gets it all. Remember, joint tenancy means the last to survive gets it all. So this heir number 1 survives you. Heir 2 and heir 3 are out of the picture. All right, let's talk about your investment and IRA account. So let's say you name heir 2 as your beneficiary. Okay, again, same scenario. Heir 1 and 3 get nothing from it. It all goes to heir number 2. And all these transfers are outright. So remember, the preditor, creditor, and divorce and spending, none of those things are protected. Okay, it all just goes outright at the end of the day. So yes, you managed to move some of your stuff. Notice the arrows to the probate court are gone. You managed to move some of your stuff to the probate court, but you still have to deal with taxes. You still have to deal with, again, the lack of protection to those individuals. I grew up with an individual who received, as a beneficiary, a significant amount of money, and quite frankly, he blew it really quickly. I also grew up with an individual who received his money through a trust, and it required him to go to school, required him to jump through quite a few hoops to actually get funds out of the trust. Okay, and so you can see how one would benefit the other. The other one spent it all and really, lost all the inheritance rather quickly, whereas the other was able to stretch out the value of that inheritance, get an education, provide for themselves. So again, that state works with joint tenancy. It did. It got it out of probate court, but it's not the most ideal. Sure. All right, now let's talk a little bit about, well, let's recap. Bank account goes to heir number 3. Okay. Home and real estate goes to heir number 1, and the investment IRA account goes to heir number 2. All right, so let's say each one of these is valued at $100,000. And you can say, look, I did a great job here. I balanced it out by using joint tenancy or beneficiary designations or transfer on death designations. I balanced it all out at $100,000. So I've moved it over there to say, okay, let's look at this first column here. The value at time of estate planning. 100,000, 100,000, 100,000. Okay, great. But let's look at the value at death, because remember, this could be 30 years. It could be an untimely death. It could be a significant period of time here. So let's take the bank account, for example, and say, all right, $100,000. There's really been no change. We'll just hypothetically say there's been some deposit, some spending, but overall remains at $100,000. So heir number 3 gets the full $100,000 value. Heir number 2, however, was the one in joint tenancy on the home. What if the home was sold? What if there's a mortgage on the property, especially a reverse mortgage, right? Or any other reasons that are out there that potentially the home is just the value, market fluctuations. And so let's say if the home is sold, obviously the value of that home to heir number 1 is 0. If there's a mortgage on the property, it could be somewhat less than the $100,000. If there's a reverse mortgage, same thing. If any other reasons, the market fluctuations, that amount now could be from 0 to 100,000. Yes, there potentially could be an upside to it, but again, that's not what you were trying to accomplish here. Now let's look at this investment in the IRA account. Started out at 100,000, but then you had great investment returns. There were minimal withdrawals. Now it's $250,000 in value. So just think about this. You started out to equalize by using this joint tenancy payable on death, or as well as the beneficiary designation based plan. What you ended up with was some severe imbalances at the value at death, ranging all the way from 0 to $250,000. All right, so let's talk about how your estate works with a will. So let's look at this, and let's go with joint tenancy and wills, and let's talk about when you put them together. Okay? Many people do this. They'll pair a will with joint tenancy. So I've moved the picture around a bit so you can see how it would work. All right, so if the bank account, right, went to heir 3, as we discussed previously, right, then they receive 100% of it upon your death. A joint owner, as I've discussed, is automatically entitled to this 100% of the property on the death of the other joint owner. It's just the way it works. As you can see in the picture, our top 2 tiers heirs are completely left out. Okay, that would be true with this as well. Remember, the home is in joint tenancy. All right, so let's talk about, some people get trusts, and I run into this quite often, okay? You say, oh, hey, look, no, I created a trust. I funded a trust. I'm sorry, it's partially funded a trust, but I created a trust. I went and saw a lawyer. I got a form online. I drafted it all up. It all looks good, right? Well, let's talk about what it means to fund a trust. A partially funded trust, and I see this quite often, where someone will come to me and say, hey, I need something happened, I want to modify my trust, and I look at it and I'm like, there's really nothing in your trust. It was created, and it can be funded at death through a pour-over will, okay, but it's not fully funded. All right, so a trust then is different. So as you can see in the graph there, a trust in that center box avoids probate. Okay, anything owned in a trust transfers outside of probate by the terms of the trust. A trust is an agreement with yourself that this is what's going to happen when you pass. Another really good thing about a trust is, when I talked about that first phase of planning where you plan for incapacity, a trust will have provisions in there as to what's going to happen when you become incapacitated. So it's really a great planning tool that kind of puts it all together. But let's look at what happens when it's just partially funded. All right, so oops, you forget a bank account. So what's going to happen to that bank account? Guess what? You're back in probate court. Probate fees, still thousands of dollars, even if it's only 1 or 2 assets, you still got to, again, not the ultimate ideal situation. Now let's talk about a fully funded trust. So you're familiar with the diagram. This is your estate. This is all your stuff. You can see them, on the slide already. During your life, however, this time you do it right. You fully fund the trust. Everything goes into the trust. After you die, let's talk about this. During your life, some people, I've heard this many times, say, well, I don't trust a trust. What is a trust? What happens to it? Do I still have control? Absolutely. When you use a revocable trust, or when you create a revocable trust, the assets are still yours. In fact, you don't have to get a separate tax identification number for it. You don't have to file a tax return for it. Everything passes through to you. In fact, you just file your taxes as you would normally. Not only that, you get to control it. The term revocable means one significant thing. Let's say you fund it and you change your mind 5 years down the road. You still terminate it and transfer everything out because it's revocable. You can do what you want while you're alive. You still control, trust, and have everything while you're alive. That's the beauty of a revocable trust. And especially when it's fully funded, because then again, you see that little slash over the probate court, you avoid that whole process. So what happens then after you die with the trust? Simply, the beneficiaries named in your trust get what you told them they're going to get when they're going to get it. Okay. Of course, so let's go. There's no probate fees, right? They do have some settlement costs, but they are significantly less, and some taxes may be due, but again, you can do your best to plan around that. The beauty of this is, go back to our situation before where you ended up with, 0 for the joint tenant on the residence that was, sold or decreased in value or had a mortgage on it, to $100,000 to the bank account, to $250,000 on the IRA and the investment. So let's just make it easy on me and say we're at $350 there, $100,000 bank account, $250, right? And we have 3 heirs. So what if we just move that up? Let's say the resident in that case had an extra $25,000, so we're at $375. So rather than this great disparity between 250 and 0, and 250 and 100 and 100 and 0, rather than that disparity between those heirs, Now, if we say we had a $375,000 estate, right, we can make it so they each would get $125,000 and level it off. It's the great thing about a trust. You can plan for the contingencies of the future. All right, so now let's wrap this all up. I have this chart here, and you can see at the top is our four columns: do nothing, joint tenancy, will, and trust. Those are all the basic estate planning types that we've discussed. And on the left-hand side there, you can see all the things that we might want to do in an ideal estate plan, going back to what we discussed at the very beginning. So estate planning and income tax planning, okay, and the do nothing, no. In the joint tenancy, beneficiary designation, and transfer on death world, no, you can't do anything with those. In a will, you can. Income tax planning is a little bit more limited. In a trust, you can do both. What about naming someone to handle your affairs when you die? Well, in the do nothing, that's the government decides that. They appoint the personal representative through the process of probate. Joint tenancy has nothing to do with that. In a will, it's possible. In a trust, you can do it. And names who you want to receive your assets. Again, in the do nothing, the government decides. In the joint tenancy world, it is limited to only those specific assets, with the designation, whoever's the joint tenant, or the designation of the beneficiary, or the transferee on the transfer on death aspect. A will, you can do that. In a trust, you can do that. Name someone to handle your affairs if you're unable to. Government decides through the process of conservatorship and guardianship. Again, lots of hoops to jump through, as well as a very public process. Joint tenancy planning, base planning has nothing to do with that. A will can't do that as well, but a trust can. Okay. What about asset protection for beneficiaries? Do nothing? Nope. Joint tenancy? Nope. A will? Possible, but more limited than trust. A trust can absolutely do that. You can put in spendthrift provisions that say creditors can't come after it, or the trustee can't release funds to creditors. You put in provisions to deal with a divorce. Okay, what about avoiding probate? Which it's a huge reason why you would want a revocable living trust. Okay, you really want that. And reason is do nothing? Nope. Joint tenancy only for those assets limited. A will does not do that. In fact, a will by its nature has to go through probate. A trust can get you out of that. Avoids a living probate. What we're talking about here is the conservatorship, when you're incapacitated. Again, all three don't. The only one that provides that is a trust. What about a private process? If you value your privacy, as I've said throughout all this is a very public process when you're in probate. There's other people in the courtroom when your affairs are being discussed. Through a trust, though, you can plan around that and make sure that you're taken care of in your decision. My contact information is on the left there. Name them, I'm Andrew W. Gilliland. I typically go by Drew. There's my phone number, there's my email, there's my website. What I want you to do is go to my website, www.gillilandlaw, make sure there's that third L in Gilliland.com. Fill out the contact us form, then we contact you back. We set up a free 30-minute initial consultation. You mention this webinar. Say, yeah, I watched your webinar on why a trust is for me, and you'll get $200 off your estate plan. The process is simple. We meet, we discuss. For the most part, once I get to know you and have that intake sheet kind of completed, and I understand who you are, your family, what you have, and what your desires are, then I will propose a plan for you. This is what I think we should do. This is what I think meets your needs. And when I do that, I can always quote you a flat fee rate of this is what's going to happen here. This is what it's going to cost. So there are no surprises in the process. What I would say is just, get it done. It may be a bucket list item, it may be just a list to check it off, but get it done, because as you saw throughout this, that whole process, if something happens to you and you end up in probate, it's expensive, it's public, and it's not a good process for your heirs. It's not a good process for your family as you're going through it. If you do have any questions, feel free to email me at andrew@gillilandlaw.com, and I will respond to those questions. Or feel free to give me a call and set up your consultation. Again, I do love what I do. I do love sitting down and helping people get through this process, and helping them think through, those deep questions that you may not have thought of. And we get the answers, then we put it down. Yes, documents are a necessary part of the estate planning process, but they're not the whole process. So I look forward to getting to know you, and thank you for participating in this webinar.